and so on. Jack, you've had, I know, great experience. You and I have worked together some time ago on various legal matters from the viewpoint of an agency. Do you have anything to say to Mr. Galloway, who said, "Don't necessarily assume that your agency has checked it out"? I'd like to hear your views.
Well, it depends on what agency we're talking about. I know that in many cases we don't want to hinder our creative people with a list, Bob, of do's and don'ts. We would sooner deal with what we could see as a legal problem in copy before or after the creative people have developed it, and then we can maybe talk about how it can be adapted or changed or pulled back a little bit. But there are in agencies people, agencies will use legal counsel, of course, and we do. There's also the in-house expert, in quotes, a role that I've been playing for a number of years. But in any areas where I don't feel secure or don't want to take the risk, of course, we always check with our legal counsel. Our larger clients have their own legal counsel on staff, and sometimes we run into the same problem as with French translations. It's hard to get two legal counsel from different firms maybe to agree on the same thing. But our client's legal counsel takes precedent. They're the client, and it's their advertising.
I think in that respect it is true. Bob and I discussed this at breakfast this morning, that every person and every company has to look after their own legal business. And is it also not true that an agency's legal concern may not be, in all respects, totally identical to the client's, although in many respects they are identical? Ken, from the viewpoint of an in-house lawyer, I haven't heard anybody yet on the advertising side use the term end run, but it's one that I certainly have heard used in relation to the lawyers. What are your perceptions? What's your experience?
Well, I guess with Bob, where he spoke about a partnership and everything, I think we're in tune, but we're not in the same wavelength, because often I hear the complaint that and House counsel are viewed with some suspicion and antagonism in some cases because they tinker too much or they wordsmith too much with regard to the creativity of the commercials that have been done. And so I think I agree, I do agree with Bob that this relationship is a partnership. You have to work together and develop a credibility with your ad agency and also with your ad managers if you're going to get along. And it'll stop end runs. It'll stop the view that the House counsel or lawyers are a censorship. And I think it's most important that they do get along and that you do develop that credibility. With respect to the fact that ad managers are procrastinators, I don't accept that. I think that there's no excuse whatsoever, in my opinion, that a ad manager can't come to the law department early on in the promotion to anticipate legal problems which will come up, and then you can resolve them there, as opposed to waiting till the last minute and you get a phone call saying, "Hey, how about taking a look at this? We've got our actors sitting in the studio waiting to shoot the commercial."
You don't accept it, but certainly you and I'm sure Ollie.
I say I don't accept it, and if there's one message I could leave with the ad people here, it's timeliness. Try and be a little more timely.
Well, let me say, Ken, that as vice president of a major company, you may say some things. I can't remember in private practice ever saying to a client, "I don't accept that." Ollie, what's your experience of the timely intervention, which I think in part is what we're talking about here?
Yeah, that's what Bob started us rolling along on, and I used the word ideal to describe the early involvement of the lawyer. But I don't think it's at all necessary that when a lawyer is asked to look at script that you leave it to the last minute if you're the client. think it's wrong for the lawyer to pick up a pencil before he picks up the script. I will always to myself to make sure that I break that habit of reading with a pencil and changing words. I walk around to the client side of my desk and leave my pens and pencils and erasers safely far away from me. But come back to the point, it's essential, of course, to get it early enough that you can have some constructive input. And when this board is being shot, and when the video has been made, and they tell you there's no room anymore for an asterisk saying only on Fridays if it's wet, you need time. But while I've got your attention on the question of time, the lawyer's time is very valuable. That's how I sell it. That's how we who are not inside the corporate cloister that my friend Ken enjoys have to account for every waking minute of every office minute of our day. I was exaggerating. There go the Irish again. That time is more productively used for you if you present the lawyer with the story. Tell him exactly the objective of your campaign. Put it in words form that what we're really trying to do here is save a company that's going to be belly up on Friday if we can't get this special campaign going. It's all about money. Or it's all about, we're trying to capture the magical thing that belongs in a Burke's bag and doesn't belong in a Meaton's bag. Tell him those things. That lawyer will understand exactly what you're driving at. And then he'll see, applying his legal formulae, his rules of thumb, if you will, how magic are you misleading? He'll leave it to you to decide whether you're attaining your objective, but he's going to make sure that it's the job for him or her to make sure that no laws are broken and that no civil or criminal exposure devolves on you, the client.
Jack, I was interested in one thing that you said, which again went to, I guess, the timeliness of legal review. And if I'm misstating it, correct me. Did you not say that that your agency favors letting the creative people do their thing before legal input, or did I misunderstand you?
No, that's right. First of all, the creative people working on a particular category will have broad general knowledge about the do's and don'ts. Where the problem is a lot in the pre-clearance through government bodies of advertising, not the legal departments of our clients, and it's the unwritten things that are not in the government pre-clearance guidelines that only come up when there's a dispute over a copy, and those kind of frustrations are a much greater concern to ourselves and our creative people than the legal. The legal involvement, the legal stamp, the legal approval of our lawyers or our client's lawyer.
Bob, as a client, would you expect that before an agency presents a new concept, and let me be specific to try to give you something to get your teeth into, assume that the Campbell's has not been accustomed to running contests. Would you, and your agency brings to you the idea for a new breakthrough, we're going to use a contest for these reasons to achieve this objective. Would you expect that your agency has had at least some preliminary discussions with lawyers, always recognizing you're not going to rely upon your agency to be your legal alter ego? Or
well, I think in contests, yes, absolutely. There's no doubt about that. I think that it shouldn't perhaps be cast in stone, but at least whether we're in the general parameters of being legal, and once we get all of the final copies that it would be finally checked. So yes, I would think so. I'd like to come back to one point. I know I started this, but advertising strategies are extremely important. I'll tell you pragmatically if someone was to ask me, what do I think of a particular ad as an ad man? I would never comment on that ad unless I asked the other question. What's the strategy? And if I see the strategy, then I can comment on the ad relative to the strategy. But I can't possibly comment on the ad in limbo because it's meaningless to me. So I really think as legal people, the same thing. If someone shows you a piece of copy to approve, I think you should turn it over and say, let me see the strategy first. And you're right, if your strategy is to try to show a Burke's bag in contrast to an Eaton's bag, then I think you should see that before you even look at the copy. And that seems so fundamental to me, and it's something I don't think is really burned into the partnership as much as it should be.
Just wondering, would it be in a sense better for a lawyer not to look at the strategy? Because when you're facing possible criminal sanctions under the Competition Act or something else, the people enforcing that legislation will be looking at the ad in limbo rather than for the strategy behind it. And I'm just wondering, would it be better for a lawyer to look at it from that perspective rather from the perspective of the strategy?
I'll let a lawyer answer that. It seems to me that goes against the partnership that I'm trying to propose.
Well, I think there's different ways of fixing something that's wrong, and if you don't know the strategy, you can fix it and kill the strategy, and then you'll end up with a piece of advertising that doesn't work. If you know the strategy, then you can be creative legally and make it legal, but without hurting the strategy. So I think you should know the goals of the advertising before you pick up that pencil and the eraser, and then you can do your surgery without killing the patient, as it were.
You're the client, but you should make sure that your judge is unbiased when you get into court, but your lawyer is always biased in your favor. And if you have to establish a bias, get him on your side, sure, what you're trying to do. And there will be a lawyer and an advertising talented person and a client all striving for the same objective. And if they're working in harmony, the lawyer can stick to his law books, but at least he knows where his partners are going.
I would put it another way. Certainly in reviewing advertising copy, the more information I have, which is or may be relevant to that copy, in my view, the better I'm equipped to apply my mind to its consideration.
And perhaps without rewriting the script to help the client solve the problem that you tell him about.
If your point is, excuse me, I shouldn't prejudge what your point is. If it is that, surely copy is looked at by the courts, for example, exclusive of the strategy, and it is misleading or not in a material respect or not, that's absolutely true, no question about it. But I repeat, I personally like to have more information rather than less in looking at the facts, because strategy is not necessarily going to be totally irrelevant in a prosecution of my client. So I repeat, I would prefer to know it. Getting back to timeliness, I remember well, I feel very strongly about this. In the course of 20 years of practicing in this stuff, I've had a number of cases, situations which have been brought to me. Being in private practice as opposed to Ken, I guess I get to see the ones that are, in many cases, that are real problems. Maybe there has been an investigation commenced or something like that. In any event, I've seen more than my share of situations in which a lot of money has been spent by a corporation before they got the lawyer and got the lawyers involved. Indeed, the ad, I can think of one involving the use of paper currency. I can think of more than one, but one in particular. Very expensive cost to the client. If legal advice had been sought in advance, and assuming the lawyer knew what he or she was talking about, the whole damn campaign would have been nixed, because it was no good. It was a non-starter, period. The client wanted to use paper money, didn't want to use something that looked like monopoly money, and it's clearly illegal. Simple as that. Assuming, now, when I say illegal, then it's up to the client to decide what they're going to do. So that's a perfect example. I mean, if all sorts of time, money, let alone production costs and so on, are going to go in before legal advice is sought, I submit that in particular circumstances, however rare they may be, can be an extremely penny-wise, pound-foolish move.
I just want to point out from the perspective of an in-house counsel going back to advertising agencies. To be the lawyer inventing advertising doesn't mean writing a legal opinion. I write legal opinion 5%, what I say. That much is on retirement, for the most part. All I want is
Can I answer part of that, Wayne? Because I think that from our company's point of view, in some cases, we insist on written legal opinions, and those legal opinions come from outside lawyers, from ad agencies that may come up with a concept. Take a contest or a promotional game. They'll develop the rules for the game, they'll put it all out, and it'll come onto my desk with the ad people saying, well, it's all approved by the ad agency, and here's the scripts, get the scripts going, and let's get on with it. The people are still waiting out in the production area, waiting to shoot the commercial. Now, in that situation, if part of the contest has been developed outside the company, then and it's been done by the ad agency and with their lawyers, I would insist on a written opinion, and I do insist on that. Why? Because I think it behooves me and our company, first of all, to ensure that if we're dealing with contest rules, those contest rules comply with the law.
Fair enough, but if you want to insist on an opinion, I suppose you should get one, but if the lawyer's signing off saying it's legal, it's just as easy to discuss it and sign off.
But it's not necessarily, it's just as easy to do that, but I don't think you have the same protection. I mean, I don't think the company has the same protection. Absolutely.
Next
Absolutely.
time you get an opinion from a big law firm, look at the line that refers to the uncertainties inherent in litigation, and you won't find that in the initials that Sheldon is prepared to give you. I think your initials are better because you'll never get an unqualified opinion out of a major law firm.
Sometimes in order to get around that, for instance, in contests, we have forms, and I don't want to put everything in a form, but obviously when you sign a piece of copy and a contest is part of it, you will have checked out certain areas, test of skill, et cetera, et cetera, et cetera. So that sometimes helps. Rather than one cold signature, it's a cold signature on a set of parameters. And if you have a particular doubt about one of those parameters, for instance, the test of skill, if you don't think it's being executed quite properly, you might want to take that portion of it and give an opinion on the weakness or strength of that particular facet of it. But I would think if you were looking for a long legal opinion, it would slow the process up, or the partnership is not working perhaps the way I would like to theoretically see it work.
I would be interested in the legal opinion on something that was mentioned in the way of a bias to the corporation or to the business. I think Oliver mentioned that you should try from an advertising perspective to get the bias working for the advertising department. But how often is that the case? In many cases, it appears that the legal bias may be in favor of the corporation in this liability sense, and in many cases, on the side of caution, they will nix any number of ideas from the advertising department. Is that prevalent in any of the experiences?
I know that in dealing with quite a large corporation where there are a number of lawyers, you get to know the ones that you send or your counterparts, the advertising people, get to know the ones to send the copy to where they can receive the most fast, not only fast, but a reception is congenial to their needs as well.
I'd like to just comment about bias for the client. When I'm reviewing an advertising campaign, I try, as far as I'm humanly capable of doing so, to be as objective as I can. I hope that I don't have any bias that's important anyway. I wouldn't be doing advertising work if I didn't, nor would Oliver, nor would Ken and so on, if we didn't believe in the advertising process. At least I wouldn't be doing it for 20 years. But I think it's important for a lawyer, I'll get out of myself, I think it's important for a lawyer, I don't care whether house counsel or outside counsel, large firm, small, you have it, to be as objective as possible. Not a cheerleader. If you're hired as your client's been charged with misleading advertising, that's when, obviously I'm exaggerating, but that's when the cheerleading function comes in. The advocates, not in giving an opinion about the likely resolution or outcome of the case, but in terms of arguing the case. It's certainly if you're in Katharine Gourlie's office trying to persuade the adoption of a position favorable to your client's advertisement, that's when the cheerleading comes in, the advocacy. But in terms of copy review, certainly, as I said, I try to be objective. I know Oliver does too. I think Oliver was not really referring to cheerleading, but more to a non-anti-advertising bias. But again, Ollie?
I have to subscribe to what you so wisely uttered.
Well, that was pretty easy. I wish Katharine Gourlie was as easy.
The answer is to negotiate, to make sure you negotiate the contract with the ad agency to begin with, and you don't have that release in there.
I just want to ask, you need to represent here. How many clients have a lack of
The silence of response on the part of the panel indicates it's a rhetorical question.
I could comment. I don't think that the state of the relationship between advertisers and their agencies on contracts is in very good shape, by the way. Over the years, I've tried many times to get an agreement, and it's very difficult to get an agreement. However, we do insist on copies of insurance that the agency holds, and that is current, so that if there is a liability, the agency at least is insured as at least a partner in the costs that might be incurred. So two parts to that. It's difficult to get a contract, but you should try. And secondly, you should insist on insurance by the agency and see it and make sure it's current.
The agencies have to depend on what clients tell us about their products and their manufacturing processes, and because of the sometimes tenuous relationship that agencies have with clients, while advertising agencies are often not in a position to demand proof of accuracy. So it becomes we feel a mutual trust relationship is the most effective way you can have with a client. Our industry maintains that we're merely agents in the creation of and supply of advertising for the people who will profit from it. And so when the advertiser signs off, we feel that our liability is okay. Although we do know that an advertising agency has been fined and has been charged and convicted, when that happened, why the Klaus's outfit said that that agencies should be very aware of their responsibility in the development of advertising. So that's always hanging over our shoulders.
I seldom, if ever, like to disagree with Mr. Galloway, but the number of contracts, Bob, that has now been written has grown considerably. At ACA, we have advocated that should be done between the client and agency, and there are more and more of them. On the point of liability on the part of the agency, I don't think any advertiser can duck behind making the agency responsible. I believe within the Combine's regulation that they hold the manufacturer as the ultimate responsible party. But I think, on the other hand, that in most of our member situations, there is a shared responsibility accepted by both parties.
Yeah.
John, just to prove that point, British Columbia about a year ago, there was an account director charge on the Competition Act, and that's also along with the advertisers, as well as being run. Certainly, some very plus years of this code, the agency is very much part of it.
If I could add from south of the border, the new commissioner in the Federal Trade Commission served notice to a meeting of the agency association in the States that they would be looking to hold agencies more responsible than had been the case up to now. So there is sort of a swing a little bit back to that shared responsibility side of it.
Well, I certainly think that that's very good news for agencies. Klaus Decker this morning mentioned on several occasions the compliance program. I would like to know any experiences that our panelists can provide in relation to the utilization of that program. Whether or not anybody has had experience which is negative, whether or not council has a particular position to take in relation to whether to utilize it. Could I ask for comments on the Bureau of Competition Policy Marketing Practices Branch's compliance program and its utilization? Ollie?
Yes, I've had a fair bit of experience in working with Klaus. And I can tell you what I hope will be a rather interesting story, because it involved the advertising ASA, who are our co-host today. They were entertaining a complaint against one of my clients that he was being extremely unfair in his merchandising television commercials in calling a competitor's product a near toy. I know in saying the word toy that some people on the panel will recognize who my client was. So they called hearings and did all kinds of noise, beat the drums, tried to scare my client. And I took a look at this commercial and said, I'm prepared to give you a considered legal opinion that this commercial is not misleading in any respect, and that it complies with all Canadian laws. And even to make you feel better, I'm prepared to get a ruling on it from the misleading advertising branch. And I went up to Mr. Decker's office with my client, and I said, well, here's a commercial that we're about to run. The advertising council is going to pull it. And will you be prepared to sit in as a judge and jury on this particular case? What I'm asking you, Klaus, is if you receive a complaint about this commercial, are you prepared to initiate an inquiry, or have you got enough reasons to refer the file to justice to launch a prosecution. And he said, well, question of toys here, and I had my client's product with me, and I said, this particular appliance isn't a toy. Now, it was a vacuum cleaner. And I said, this has me convinced that it is a most wonderful unit that will do everything my client is claiming for it. I mentioned this morning I smoked a big pipe. I took it out and it was full of ashes, and I emptied it in Klaus's brand new carpet and ground it in under my heel, and then gave it one swipe with this vacuum cleaner. It was immaculately clean instantly. Now the president of the company was lying a dead faint. But I got my ruling. And there's a case where there really is a law. We heard this morning, where do you go and appeal? And there was, perhaps innovatively, but access was granted by a person whose job it is to prosecute advertising that's misleading. Gave us a clean bill of health, and we ran that. It's not a toy commercial on television. Yeah.
Was it a brass vacuum cleaner?
I think you know that I don't include my client during the call to my client. But I once had a situation where I had no idea what I had on the client, and I refused to do that. I thought it was illegal. But I thought this was too possible. And I thought it was nice. If the advertising purpose is illegal, why send it to us? Nobody isn't. And we know the advertising. You're trying to assume.
The word slick springs into one's mind. Ken?
I agree with that gentleman's comment.
Sure.
I stay away from pre-clearance and pre-rulings as much as possible, and my experience has been that if you're on the borderline, you go in there, they ask for the cost to correct the situation is more costly than it was to produce the commercial in the first place. So, if at all possible, we try to not encourage pre-clearance. Or I do.
Jack?
Well, pre-clearance to us, of course, it's mandatory for food products through commercial and corporate affairs, and through drug products through Health and Welfare Canada, Health Protection Branch, and then through with beer through the liquor boards. So those, and then the Quebec government for children's products and contests. So those are all mandatory things we have to do. We really don't. I don't feel that we get involved very seldom with areas that under the Misleading Advertising Competition Act. It's mainly the regulators' guidelines, which often are their viewpoints are unpublished, that their decisions are arbitrarily and subjective and inconsistent, and that's where our frustrations come from and the agency has to walk a fine line between the regulators and the clients. The client expects the agency to fight tooth and nail with the regulators to defend their copy or any deletions. On the other hand, the agency has maybe 3 or 4 other clients that they are dealing with these same regulators on other products. So going to the wall for one client can kill you for the next time you're going back and talking about on behalf of another client. So that is to us, is one of the major frustrations.
Advertisers? Any thoughts?
Well, perhaps it's time to call a halt. We've gone a little bit over the announced time, and I hope you have enjoyed listening to the assembled specialists in the field, and I have certainly found a great deal of positive output from it. On behalf of my co-chairman and myself, this session is adjourned. Thank you.